I thought I just heard the current speaker, and that was Jeannie, say that the telehealth provider must be licensed in the state where the patient is located. Is that correct? If so, doesn't that defeat the purpose of telehealth?
Well, this is Karen. I can start. Jeannie can follow. From my read of the proposed rule, that is correct. The recommendation, the requirement will be that it's within the state. The provider, telemedicine provider, must be licensed in the state where the patient is. Quite frankly, that does not defeat the purpose of telemedicine. I think we should, in our comments, those who wish to comment as such, address the potential of future regulatory changes within the states related to licensure, because it's possible that working with the FSMB, that there may be some compacts for medical licensure, and we would hope that perhaps CMS would consider then licensure involved in any potential future compacts to be in compliance. Jeannie, you may wish to comment about that as well.
Yeah, it goes back to accountability and assurance of responsibility for the patient, and where is the patient receiving services. And you would not want to receive services from a physician that's not even licensed within your state. And I'm speaking very as a practitioner and as a person in general. In the future, if we get to the place where there's reciprocity and so forth and compacts with physicians, of course we would look at that and other practitioners and consider whether or not we needed to make some revisions to the rule.
Okay. Next question. Have these discussions and proposed COP changes been discussed with AOA, HFAP?
AOA, yes, and I'm drawing a blank on the other initials.
HFAP. Perhaps the questioner can send another text in. And
HFAP, that's AOA. HFAP is AOA, and yes, we have discussed it with them, but I will tell you that they have been enforcing our requirements exactly as they are right now. And they will come. They will match our requirements when the final rule comes out.
Okay. Next question. We are a specialty practice of physicians that provide emergent psychiatric evaluations to hospital emergency rooms in numerous hospitals. We are not hospital-based ourselves. How will these new conditions of participation impact the credentialing and privileging of our physicians?
Those physicians in that practice need to go through the regular credentialing and privileging process that the hospital has, where they review their credentialing and their privileging packages and make recommendations to the governing body.
Okay.
So in essence, it does not impact how they function right now at all. By the current requirements, they need to be submitting their packages, having them reviewed and approved by the hospital.
All righty. If a distance site trauma physician gives advice and suggestions on how to treat a trauma patient in the referring ED, is that physician treating the patient and therefore needs to be licensed in that state? I think the answer to that would probably be dependent upon state law. In some states, there may be flexibility for that. In other states, the state law is written in such a way that that probably is not, you would not be in compliance with the state's licensing requirement.
Okay, Karen, you're right, a little way on this also, but it goes back to, again, where the patient is and the physician having license to work within that state and provide consultation and services.
Right. I think some of the states have a consultation exception, but again, I think state law would, in terms of licensure, would prevail. But in terms of hospital agreements, clearly there would need to be agreements between the entities, right?
Okay, Nick.
Yes, exactly.
I mean, I want to be respectful of the time because Dr. Raban has to see some patients at 1 o'clock and Jeannie has to meet with the president at 1 o'clock. So.
Not exactly, but I do have a 1 o'clock commitment.
Oh, you do have a 1 o'clock commitment. Well, I thought you said it was with President Obama, but that's okay.
He was driving by. He was heading to Baltimore.
There you go. He was on his way to Baltimore. Well, anyway, I was gonna make a little joke about that. But that's okay. If a critical access hospital is not Joint Commission accredited, can they still accept the credentialing statement from the distant site as long as both sites participate in CMS?
And I think I answered that already, but I will reiterate it. Absolutely.
Okay. I've been asked to reformulate the question on the advice to remote EDs in terms of credentialing, not licensure. So if you provide advice to an ED, do you have to be credentialed?
I guess I would have to go back and ask, are you providing that advice as from a distant site hospital? I mean, there has to be some kind of agreement, a relationship arrangement, or that person wouldn't be being accessed in the first place. You agree, Karen?
I do.
So the answer would be yes. They would need to, these regulations would impact them.
Okay. All right, we have a few more minutes here, and we still have time for some additional questions. Please feel free to submit them. And I think it's one of the things I think is very important to re-emphasize that you said, Jeannie, is the provision in the guidelines and the proposed regulation that allows the originating hospital where the patient is located the option of how to participate in this. The fact, and this I think is probably a very important point to drive home, because there will be some hospitals that probably their risk management folks and whatnot will not want to engage in credentialing and privileging by proxy, and it's important to drive home the fact that they don't have to do it. They can do their own credentialing and privileging if in fact that's what they want to do.
That's correct.
If another question from the audience, if an independent group of telehealth providers have an arrangement with an originating site, is the originating site responsible for the credentialing and privileging?
Yes. And you are calling the originating site the site that's receiving the service. Correct?
Correct.
The answer is yes.
Right. Okay. Are there any, for purposes of communicating with you and others at CMS on this, could you take a moment for those of us who are not familiar with the rules and regulations with regard to what kind of communication can occur outside, not the official comment communication? Are you forbidden from talking to people about this until the guidelines close?
Actually, we are.
Okay.
Based on the Administrative Procedures Act, once we put the regulation, I don't know if you can hear my phone ringing, but I'm sorry it's ringing.
That's okay, not a problem.
President Obama, sorry.
We are not allowed to discuss beyond what I've told you. We talked about what is in the proposed rule. We cannot talk with you about the direction we're going to take in response to comments or anything. And it all boils down to, if we give one person the opportunity to weigh in and attempt to guide us, then we need to open that up to every single person in the country. It's equal opportunity for people to respond. We can meet with people and we can hear what they have to say, but we will be in the listen-only mode. So we cannot, at this point in the rulemaking process, once we start a regulation, cannot deliberate, ask for direct feedback, or have meetings specific to the content of the regulations with anyone.
Okay.
But we are certainly always willing to listen to anyone that wants to come in and talk to us. But you will get the response from us very interesting. We'll take it into consideration because we cannot discuss it by law.
Gotcha.
Jeannie, this is Karen. I have a question for you as well. And what I'm wondering is it useful to CMS to receive positive comments in terms of the support from the telemedicine providers for what is already existing in your proposed rule, or do we stand silent in that regard? Is there a preference?
Positive comments or negative or recommendations for revisions. I know you can't hear my other phone ringing.
It's President Obama.
Nobody wants to. So any comments that support what we've done will help us in our determination of whether or not to make any revisions.
Okay.
Based on the negative comments that we received.
Great.
Okay.
All right. I think we have time. I have one.
Yes, positive feedback is always a great thing.
Great. And it helps at review time, right, too, right? Just kidding. I have one last question, and I have room for one more if another one comes in by the time we're done, but then we're going to wrap up. If the telemedicine equipment is located in an area that is considered an outpatient area, will the specialist still need to be credentialed?
If the outpatient area is part of the hospital, bills under the hospital provider number, is considered an outpatient department of the hospital, yes.
Okay. And that is our last question. We have two very busy people who have to move on to other facets of their afternoon. Thank you again for participating, both Dr. Ruban and Jeannie Miller. We do appreciate the information you shared today, and I hope that it's been very helpful to the community to participate. Again, we want to thank Drinker, Biddle, and Reith for their technical assistance in making our brown bag telehealth seminar a success. The IT team went over and above the call of duty on this one because we did a few wrinkles in our process. A reminder again to mark July 19th on your calendars for our next brown bag seminar. You heard some of the questions here today on consultation, and it's a very strong possibility that our brown bag on July 19th will have to do with medical consultation and laws in the various states as they apply to that. And again, we thank you for joining us. If you found this seminar to be helpful, please consider joining be a member of CTeL. And we look forward to having your participation in future brown bags. Thank you very much. Have a good afternoon, and thank you for joining us.